A legal firm representing former President Donald Trump's campaign has called it quits.
Oh no!
The firm LaRocca, Hornick, Greenberg, Rosen, Kittredge, Carlin, and McPartland on Friday had requested to remove itself from a case, citing an irreparable breakdown in the attorney-client relationship. Oh, really? So let's get into the details. So the firm was actually representing the campaign against a lawsuit filed by a former campaign surrogate, AJ Delgado, who alleges that the campaign had sidelined her in 2016 after she revealed that she was pregnant with, well, top Trump aide Jason Miller's baby. Delgado accused Miller of engaging in a cycle of sexual coercion, rape, sexual assault, abuse, battery, sexual harassment, and sex trafficking. Wow. That's, wow. So, on the coercion thing, right? So, she says that she was afraid that her job in the White House or any position in the Trump orbit would be affected if she would refuse the demands of Jason Miller, which often, were, to get into a little bit of a detail here, a demand that she have unprotected sex with him, which she obliged because she literally had his baby. So now she had the baby in 2017, and since then she claims that Miller is a deadbeat dad that doesn't pay child support. Wow. Look, I don't know what's true, what isn't true. In an interview with The Atlantic, for example, Delgado previously referred to a brief affair with Miller as a really nice, sweet relationship. Well, I mean, you said that then, now you're saying this was a cycle of coercion, rape, sexual assault, abuse, battery, harassment, and trafficking. Those are wildly different positions. So I don't know exactly what here is true. All right. That said, getting back to the law firm, the timing here is quite interesting because the New York Times noted that this had happened just 2 days after the same federal court had ordered the campaign to turn over in discovery all complaints of sexual harassment and gender or pregnancy discrimination from the 2016 and 2020 campaigns, materials that the defendants have long resisted handing over, meaning that they have materials, which means to me, says to me that they had a lot of complaints of harassment, gender, and pregnancy discrimination, which doesn't surprise me at all. I mean, after all, it's the Trump campaign right-wingers. Yeah. Again, not shocking at all to have them have lots of complaints from female staffers. Look at who they are. Anyway, the fact that they're refusing to turn over this material basically lends her side credibility because it establishes that there was a lot of this going on during that campaign, both of those campaigns. So now that brings me to the irreparable breakdown portion of this. What do they mean by that? Well, unfortunately, they haven't given really any details on what that really means. That's just their explanation here. We get an irreparable breakdown in our relationship. Oh, it's like irreconcilable differences. Doesn't really give you a whole lot of information. That said, they have signaled that the campaign might want to keep them on board anyway, which I think is rather odd. So the law firm wants to leave, but the campaign might not want them to leave? That's very, very interesting. And of course, the other side that doesn't want the law firm to leave is, of course, AJ Delgado. She argued that this entire thing stinks to high heaven and should not be allowed until the discovery process has been completed. Now, that discovery process was scheduled to be completed fairly soon, within days. So having them pull out at this time, that is really strange. Now here's what Delgado asserted. The firm cannot be permitted to withdraw in the middle of a compliance on a pending, imminently due specific order. This is aforementioned seeking to swap players in the field while the play is already in motion. Once again, very strange. This firm has represented Trump's business interests for at least a decade in his campaign in both of Trump's previous presidential elections. And they even represented him during the E. Jean Carroll rape trial and in a 2016 NDA case brought by another former female aide. To have them break from this case seems bizarre, since they've already represented Trump and his business interests in his campaign for quite some time through some pretty serious cases. So I don't know what this difference is. I don't know. I mean, the only thing I could think of is perhaps to delay the entire thing. That said, in this case, the judge can compel discovery, issue sanctions, or even issue a default judgment if they, fail to turn over those materials. Delay seems like what they're doing. That seems like their best shot. And it seems likely that they will get that delay. Magistrate Judge Catherine Parker has requested the firm stay on until she can schedule a conference to hash out the issue and then determine how best to move forward. So it is possible that there could be a delay. I mean, if she lets them, find new counsel, and I mean the Trump campaign, and lets this counsel leave, well, then they're going to have to delay to get the new counsel in, to get someone hired who's going to represent them and get them caught up with everything in the case, and then go forward on compelling discovery. So we'll see what happens. I don't know. What I do know is, at least going back to their reasoning, they can't say that they weren't paid for their efforts. In fact, the last payment that I'm aware of was on March 25th of $15,103.90 by Trump's Make America Great Again PAC.